This is Headnotes, a podcast from Whitehead Monckton.
Hello and welcome to this Headnotes podcast on domestic abuse. My name is Jack Staker. I'm a senior solicitor in the family team and I'm here with my colleague
Isabel Palmer, and I'm a solicitor in the family team as well.
And we are here with our special guest, Holly Broadley from Oasis.
Hello, thanks for having me along.
Yeah, you're welcome. Thank you for coming. So we've got a number of themes here that we're going to discuss this morning about domestic abuse. But I think before we do some of the perhaps heavier hitting bits of what we're going to go through, it'd be nice to hear from you, Holly, about yourself, your work with Oasis, and obviously what Oasis is and what you do.
Okay, so I'm the partnerships manager at Oasis Domestic Abuse Service, which is a charity based in Kent that supports anyone who's experienced domestic abuse. A little bit about the charity. So we support men and women who've experienced domestic abuse, and we do that in a number of ways. We provide refuge and safe accommodation for anyone who needs to flee their home. We provide practical support to help them to heal from their trauma, and we provide help to ensure they can build a safe new life. The charity supports around 1,800 people every year, men, women and children. I came to the charity a few years ago, actually following a career as a family law barrister. So it's great to be on the podcast today talking about legal and domestic abuse issues. And I now work with companies and also work on the legal support that we provide to clients.
Cool. I think we should probably explain for our listeners that domestic abuse generally is sort of an umbrella term that sort of encapsulates a number of issues really, or things that we need to be aware of. So it's not just sort of physical abuse, which is what perhaps the majority would think that domestic abuse is. It's not linked specifically or immediately to that. There's also the coercive and controlling behaviour. It can be emotional abuse, it can be sexual, it can be psychological. So it's an umbrella term that encapsulates a lot of different sides. So in your work with Oasis, do you deal with obviously men and women that are suffering from all or have suffered from all sorts of domestic abuse under that umbrella?
Absolutely, all varieties. And with domestic abuse, it is something that many people won't recognise that they're experiencing for a long time. And that is probably because it doesn't always follow a certain pattern. So some people will only experience, for example, economic abuse. So their partner might restrict their ability to access their own money, might withdraw use of the car when it's needed so that person can't get to work. Might sign up to debt, up to credit in their name without their permission. You might have someone that is just experiencing that form of abuse, and they may not recognise themselves as experiencing domestic abuse because it doesn't fit into the sort of the perception of abuse as being physical injury. So that's partly why, as a charity, we work really hard to raise awareness of abuse so that people can recognise whether or not that is something that they're experiencing.
I found it really interesting as well because there's so many hidden types of abuse. So one of the examples that I found quite shocking was a partner who tries to encourage or to keep their partner pregnant, and that's being sort of a form of keeping someone vulnerable. And it's things like that, I think, that can make it quite hard to recognise.
That's right. I mean, we find with abuse that power and control form a very large part of it, and that can be exercised by an abuser in a number of different ways. We certainly know with pregnancy that a third of all domestic abuse starts when a woman becomes pregnant, and that's certainly something that I saw in my practice. So yes, it is a time. There are a number of reasons for that, but it's a particularly vulnerable time for a woman. Absolutely.
I mean, in terms of the work that you do and the work that we do, obviously as solicitors, we will come on to talking about the types of and generally the work that we do. your involvement generally with the courts, what sort of things do you assist your the people that you deal with? What sort of things do you do with them?
So when people come into our service, they're assessed by us, and if they meet our level of criteria, and unfortunately that's simply down to capacity. So we often deal with the most high-risk cases, those people that really need help with safety planning, for example. We will assess what their needs are, and they could be anything from help accessing a GP or medical services to moving to a refuge. And for many, it involves help with the court process. For a lot of people who've experienced abuse, it could be help with that first report to the police, and from there, help going through the criminal justice system. But we have many clients who are anticipating or are dealing with the family court system. What we currently do is we make sure that our clients are referred to qualified legal advice on protective orders. That's really important to us. Legal aid is not available to everyone, and it's not available to everyone who needs it and who's experienced domestic abuse. But it's important to us that everyone gets a chance of proper qualified advice at that very early and important stage. Unfortunately, for those who don't qualify for legal aid, help with things like divorce proceedings and child arrangements orders is difficult. And I don't think any charity has solved that. So we have partners who we can refer to, and our specialist staff will support at court where capacity allows. But unfortunately, it's not as much as we'd like, and we would love to have the capacity to support more of our clients at court.
I think you mentioned their protective orders. So I think that's probably what we should now sort of, in one sense, move on to, because a big part of what we can do, obviously, for clients coming to see us that have concerns about domestic abuse, is if they feel that if they are suffering from domestic abuse or are at risk of suffering from domestic abuse and want to talk to someone, obviously, first port of call is always come and speak to a solicitor. The sort of protective injunctions, there are generally two main sorts of protective injunctions that we can assist with, and they are non-molestation orders and occupation orders. So what you will generally, or what lots of prospective clients that come to us with these kind of issues find, is that when they go to speak to the police about the issues that they're having, they will generally get pointed to us or in our direction to start with. And this is what we'll generally need to discuss with them about seeking a civil injunction, the non-mol or the occupation order. I mean, in terms, do you want to just take them through the difference between the two?
Yeah, so I think obviously it's important to note that obviously if you ever feel unsafe in any kind of situation, obviously your first port of call is and should be the police. And obviously they have the power to make immediate sort of actions and methods of protection for you. But a lot of people can often feel quite let down by the police, or there's kind of a rhetoric that domestic abuse is domestic, it's not a police matter, and they will signpost you to, like Jack said, go and get a non-molestation order, go and get an occupation order. So both those types of order are under the Family Law Act 1996, and you can make them sort of on an urgent basis if you need to. So the difference between them, obviously, so a non-molestation order is kind of akin to what most people think of when they think of a restraining order. But obviously a restraining order is a type of police action, and a non-molestation order is a type of civil injunction. So it can stop you from being contacted by your abuser, from being harassed, pestered. It can prevent them from coming within a certain distance from you, or your house or your place of work, and it can also apply to your children as well. So it can stop your abuser from going to their school or within a certain radius of their school, and things like that. So it can be a really helpful protective measure, and obviously huge peace of mind for people who are affected by that. And an occupation order is slightly different. Courts, I think, are less inclined to make occupation orders. And
I
they've been,
think it's generally more difficult to get.
Yeah, and they've been described
non-molestation
as being quite draconian, because occupation orders are all about restricting rights of occupation in a property, in a family home. And it's typically where the family home is jointly owned and one party is seeking to exclude the other party from having occupation of that house, on the same basis that it's for their protection. And a judge will obviously review the evidence and consider whether it's necessary to restrict that party's rights of ownership and occupation of a property that they own for the other party's protection.
Great. I think generally, and again, there's a constant theme when you're dealing with matters of domestic abuse that urgency really is quite a key thing. So if, again, you are or believe you are at risk of suffering from abuse, if you're going through perhaps a separation, or it doesn't even need to be that, if you're engaged in any sort of, or seeing any sort of potentially damaging traits by an individual, and it has to be an associated person. I think I'll just cover the point. When you're applying for a non-molestation or an occupation order, it does need to be a person that's associated. So generally we're looking at close family members, people of...
Yeah, spouses, former spouses.
Spouses, yeah.
Partners, people you've lived with.
Yeah, so if you need obviously more details, a solicitor will be able to tell you obviously who persons associated are and assist you in those sort of areas. So I think moving on, I mean, in terms of just covering off the urgency points, and I think, Izzy, you touched on it about when you apply to courts for a non-molestation and or occupation order, you can apply on two bases. So you can apply either seeking a without notice hearing, or you can apply essentially on notice to the other person. The difference being, of course, that if you're able to get a hearing without notice to the other party, then essentially the court will hear your application in absence of the other person, so they wouldn't be aware that the hearing is going ahead. And obviously in those circumstances you're asking for them to make an order in their absence. So essentially put the order in place, and once the order has been made and you are therefore protected by that interim order, then essentially the respondent will be made aware that the order is in place, and essentially will have the right to respond to the order that's been made, but it will be at a later hearing at a later date. There is obviously, it's going to be a question of urgency, and we're looking at how the sort of behaviour, and you'll have to obviously explain within the application the need for the urgency within the application. So they can be sort of difficult to get, but it shouldn't be put off from applying on that basis if there really is a need for it. I think it's turning to you, Holly. I mean, in respect of the sort of non-molestation and or occupation orders that you assist with, do you generally assist with, are you able to point them in the right direction in terms of the applications that people are doing, or can you assist in that regard? Or
yeah, so we're clear that we're a domestic abuse support charity. We shouldn't be giving legal advice. That's not our specialty, and there are plenty that have that as a specialty. So we work with a number of partners who we can refer our clients to. That is local solicitors, but also some charitable organisations. The Ministry of Justice is really heavily behind an organisation called FLOWS, finding legal solutions for women survivors. But they have a system called CourtNav, which is for men and women, which is an online system which assists people in filling out their details and sharing the experiences they've had, and having that then referred to a solicitor to look over before it's submitted to court. So it's a really good system, and that's certainly one that we use, and that the Ministry of Justice is keen for more people to use, so that more non-molestation applications that go before the court have had legal advice from the start. What I would say is, I think and it's been recognised that there is still a bit of a lag in knowledge in the legal sector and amongst the judiciary in terms of other types of abuse still requiring protection. So an example of that is that if you have recent evidence of physical abuse is generally going to be, I would say it's generally going to be easy to secure a protective order. Putting together evidence of 20 years of coercive control can be so much harder, and I would say, and research says, is not considered in the same way. Still downplayed by the courts, despite the fact that the risks can be greater, and victims will say that actually the coercive control could really be felt to be much worse for them than actually physical abuse.
Yeah, I would agree with that, and I think we've both had cases where that's been the case. And ultimately, it's a question of what evidence is put before the court, and it can be really difficult, I think, to gather that evidence and have it in a format where it's really clear that there is a pattern of behaviour. And particularly evidence in itself, I think, can be hard to gather.
Yeah, I mean, the sorts of evidence really that we're talking about are, obviously you turn to any sort of police, any referrals made to the police or any reports that have been made to the police. But it could be sort of testimony from yourself or from third parties that might have witnessed any singular events, or anything that can corroborate anything that you then move on to put into an application form. It could be sort of messages that you've either received or either verbally, voicemail messages, or text, or things like that. So you're sort of trying to piece together, more than anything else, the evidence that you have to formulate your sort of general position, or what you want the court to be aware of. It can be a tricky task for anyone, really. And it's also appreciated that when you're trying to gather sort of evidence for this kind of application, it's not obviously a nice thing to do. It could be quite triggering in what you're being asked to review, or sort of go back over times in your life that really haven't been that good, or that you really want to try and move on from. So it can be sort of harrowing in one respect to do that. So obviously seeking some support and guidance as you're going through that's going to be, I think, quite important. Yeah,
and I think what can be difficult as well is you end up with more of a he said, she said situation, and especially if it's an instance where obviously there are times when the evidence can be really clear, you can have messages, and sometimes they can be quite obsessive. So you've got a really clear pattern of escalation that you can use as evidence. But sometimes I think perpetrators can be quite careful and quite calculated not to commit anything to writing or to video or something like that. And in that case, you're left in a position of what can you use, what is available. So what do you at Oasis kind of do to circumvent those kind of issues?
I don't think you can circumvent them. I think evidencing domestic abuse can be very difficult. There will be straightforward cases where you have photographic evidence of injuries sent to friends shortly after an incident, which are obviously easier to evidence. I think something that we would really like to see is more in-depth training of the legal profession and the judiciary on how victims of domestic abuse present. One of the areas, for example, is the physiology of trauma. So how a victim will present is often not what a person would expect. Okay, it doesn't fit into the category of a typical victim, or what we perceive as the public to be a typical victim. So an example is that when in states of extreme fear, the brain changes, and so it's actually biologically the case that a victim's memory will be not as good following an incident, and they'll find it harder to recall. Trauma affects people in different ways, and we know about fight and flight, but there are other categories that people fall into, including fawning. Now, fawning is, I can't speak as a specialist here, as an expert, but as a general explanation, a victim will need to do what they can to keep themselves safe. And one of the ways to keep yourself safe is to make life as easy as possible for the person who's abusing you. Okay, so it may well be that after an incident of abuse and a really bad attack one evening, the next morning the victim is texting the abuser, trying to placate them. I hope you have a great day. You know, I love you. Because they're keeping themselves safe. They've just experienced something really horrendous. You put that before a court, of course, we all know what that looks like. And it would be a fair comment to say that doesn't look like how someone would act if they've been abused the night before. But actually, physiology tells us that it is one of the ways that someone would react. And so I would really like to see much wider awareness of that. That's not something that I was aware of when I was a barrister. I'm not expecting anyone to be aware of that, but we'd really like to see that sort of trauma-informed working much wider, known much more widely. And I think that would actually really help in resolution of cases, because it's going to help with that understanding of how people behave in those situations. And hopefully that would give the profession and judges the tools to find it easier to determine whether, you know, the he said, she said cases.
No, that's true. But so I think where you have the issue where perhaps people are scared to present all of that evidence, or, you know, they can't potentially fund, you know, the application for an injunction, perhaps they've lost trust in the police and they want to explore what other options are available to them. Sometimes we'll sort of assist in trying to resolve cases before they hit the courtroom by way of something called an undertaking, which, just to explain to our listeners, is essentially kind of like a legal promise that you're making to the court. So you're essentially swearing to do or not to do something. And the difficulty with that is that if you're not in court, it's not necessarily enforceable. So you are just kind of taking someone at their word, which I'm sure you might have experiences, Holly, where, you know, abusers don't accept the behaviour that they're being accused of, and so they're not willing to sign any kind of paperwork that says...
It's a difficult ask, really.
Yeah.
And undertakings obviously can be given on the basis that they're making no admissions as to the behaviour sort of contained within. But it's appreciated still that it is quite difficult, obviously, to achieve that kind of outcome in these kind of circumstances. But as a sort of precursor to court proceedings, or to avoid the ongoing need for sort of further hearings, because as a process, it's not simply the case that you apply and that there'll be one hearing to determine the issue. These matters can rumble on for a period of time, or be subject to a number of different hearings to sort of determine whether at the end of the matter, whether there needs to remain a protective injunction for a period of time. So sometimes by looking at alternative ways to settle things that will still provide the protection for an individual, might not be, or might actually be in the circumstances, the better option. So I think perhaps it might be better if undertakings or different ways of doing things are perhaps more known to the public. Do you think that would be a better, or something that might be helpful, if they knew that there was sort of alternatives to having a formal order?
I certainly think that often we can all get tied up in whether or not it happened at that point. Did it happen? I don't want to agree to this. And I always agreed with the judges who would say, this is a cooling off period. We just need to cool everything right down. We want no incidents. We want no problems between the two, so that we can deal with everything else. Obviously, from the point of view of a victim of abuse, having a protective order of whatever variety in place is going to help them, you know, mentally as much as anything else, to know that it's there.
One thing that we tend to find in terms of obviously immediate actions that parties, that either victims or I think sometimes perpetrators as well, can sometimes take immediately if there's been one sort of determining event. So if there hadn't necessarily been issues between a couple before, but there sort of has been something that's triggered something relatively nasty. What we generally find is sometimes clients come to us and say, what can I immediately do to try and protect myself or my children or whatever the case may be. And there are sometimes immediate actions can involve things like immediately changing locks at family homes and taking measures that they think are obviously necessary for their protection but may not be supported in law. Again, what we generally would say in respect of issues like that are that if you feel that you need to take a preventative measure, obviously for your own protection, in respect of, for instance, the family home and changing locks, then essentially you can do that. It is something that you can do for this type of matter. So if you are obviously in need of protection for yourself or children, then either removing them from the family home, taking them to parents or relatives, or to an unknown rented accommodation, or whatever the case may be, you can do that. But also if you feel it's necessary to change locks at a property that might again be jointly owned, so not necessarily something that you can generally do without the other party's permission and the normal course of events, in these kind of circumstances is something that you can do, just to cover off all the bases, I guess, with immediate steps to be taken in this regard. But we get quite a lot of clients obviously come to us and say, what are the immediate steps I can make to sort of protect? And I think that's one just to be made aware of.
But I would also say that does obviously have its own consequences. So I think it would be relatively important to take legal advice before taking that step, just so that, there's not anything unforeseen and you're prepared to tackle, I suppose, the other side of that.
Yeah, and we would say, as a charity, we would love to see more referrals from solicitors and legal professionals to services like ours in that situation. So if you have a client who you're concerned about who's reporting that they're in fear and they've experienced domestic abuse, send them our way. We have a helpline, and anyone from East Kent, Thanet, Medway can call our helpline, professionals as well as clients, and we will help them with safety planning. So you as lawyers are doing a great job in helping them get the legal protections in place, and we can help with those practical steps. Have you thought about the way you walk to work? Have you thought about the safety measures that are on your property at the moment? All those types of things our specialist staff can help with as well. And we'd like to see more referrals coming from lawyers. Don't worry that whether we're too busy. We'd rather that clients are signposted to us or to the local domestic abuse service.
I think what it might be worthwhile touching upon as well is how domestic abuse obviously interacts with other matters that we generally deal with in other areas. So, for instance, we as family solicitors deal with a lot of sort of divorce and finances cases, particularly financial remedy matters, where conduct is a factor that is considered when you're looking at division of matrimonial assets as well. So where conduct, whether there is a need to consider this sort of domestic abuse in light of or under financial remedy proceedings, I think it's worth touching on that as a factor.
Yeah, and I think, obviously, notwithstanding what we are about to say, you can't really understate how much being a victim of domestic abuse is impacting on our clients' kind of thinking. And when they come to us, they can be in a vulnerable state. It's obviously going to be fresh in their mind and at the forefront of what they're thinking about, their safety, their children's safety. So it can be quite a difficult thing, I think, to hear when, that's going on. You've got to think about a divorce process. You've got to think about how to untangle yourself financially from your former partner. And then obviously thinking about how it all ties in together. This is where we sort of come in and we give the advice about financial remedy proceedings and how the courts take the view of domestic abuse. And it's not something that typically plays too much of a part, unless, I think they call them sort of the white tiger cases, don't they? It's got to be really quite extreme, and it's got to be financially linked.
As a general, conduct in financial remedy proceedings is generally linked to severe financial misconduct. So there's when when people may be looking initially online, might not have spoken to a solicitor yet about breakdown of relationship, and they just see generally the word conduct, and what that might mean to them is that they will obviously have the court will take the view that because of what they might have been through in personal life, or what they've been put through, the abuse that they might have had to deal with, that's all going to be taken into consideration when we're dealing with division of assets. Is not necessarily immediately the case. So I think it's just worth noting that as a distinction between finances generally and obviously these more sort of pertinent matters that deal with simply domestic abuse and preventing it from happening further. Do you get at Oasis, Holly, when people come to you, obviously with domestic abuse issues, and they might be going through separations and these type of proceedings, do you get many questions surrounding that, on what you can do to sort of assist them with?
We do have quite a few clients who are going through proceedings, some of which are divorce proceedings. And I remember from my practice, it's always so difficult explaining to a client that while in children proceedings, these factors were really relevant and what she experienced was absolutely relevant. And then suddenly we're in divorce proceedings and we're saying, yep, court is not going to listen to this. And that's a really difficult distinction to explain. Really, from my memory, courts would be looking for the gasp factor when it came to conduct. And there is some discussion now about the fact that, well, actually, maybe what makes us gasp might have changed. And maybe when you work in the court process, you see so many cases that actually your threshold changes for what makes you gasp. But actually, what does the person on the street think about domestic abuse and how that should reflect in financial awards? There is some really interesting discussion on this at the moment, actually. So the Law Commission put out a paper last year, which was a general scoping paper looking at financial remedy proceedings and whether the law needs to be looked at again. Obviously, we were discussing earlier about how, it dates back to 1973, so it's a little outdated, you might say. But part of what they were looking at, actually, was the conduct point, was domestic abuse. And they called upon a paper that had been written through the Nuffield Family Justice Observatory, which actually looked at women going into financial proceedings before and after. And they found that women who had experienced domestic abuse were generally far weaker than women who hadn't going into that process. So they were less likely to earn well, they're less likely to know their partner's income, they're less likely to have assets in their name, they're more likely to have dependent children. And looking at the end of the process, 5 years after proceedings had finished, they were also more likely to be financially disadvantaged. And so what that paper was saying was, look, maybe we do need to look at this again. It's not clear that the current process is meeting the needs of this group. And that they also noticed that there's a real focus for that group on achieving a clean break. I certainly remember that from practice. That was a really, really key point for those clients. But that can come at a real cost. And that maybe that is contributing to the weaker financial position afterwards, because you're not having ongoing spousal maintenance. Now, there's lots of arguments around that, and you can absolutely see why a victim of abuse would not want ongoing spousal maintenance. But it's interesting that the Law Commission looked at it last year. So, it'll be interesting to see whether that is something that's looked at in a little more detail. Yeah. The caveat is it would likely increase the amount of time it would take to get through proceedings, wouldn't it? Which is already quite significant if it gets all the way, obviously, to a final hearing. So, got to consider everything, I guess, in that regard. But
yeah, and I think actually on the subject of potential reform, it's worth noting as well, obviously Practice Direction 12J, which is still relatively recent, and which applies to children proceedings or any proceedings where there are children. So it can apply to domestic abuse proceedings and financial remedy proceedings. And it's essentially the court's way of bringing domestic abuse to the forefront. Do you think it's made a significant impact, Holly?
I think it's a helpful steer a helpful focus. I don't recall, for example, under 12J, I think it's right that there should be early identification of vulnerable people in the process, which would cover someone who's experienced domestic abuse, and that there should be measures looked at for them to fully engage in the process and give their best evidence. My personal opinion is that isn't necessarily happening in practice. I don't know whether you've had clients who have been assessed as being vulnerable in that sense. But sometimes these steers are helpful, and there are positive changes coming through. Last year, the guidance on parental alienation was really, really helpful, because that was often used as a defence by people that had been accused of domestic abuse, and would hugely prolong proceedings and cause enormous emotional stress to victims of abuse. And there was updated CAFCAS guidance with the intention of being more trauma-informed. All of these steps are really important, and long may they continue, but they have to be backed by proper training and by, I would say, collaborative working with support services, so that everyone knows how to support victims, and hopefully those cases will be easier to grapple with.
And I think what a lot of people aren't aware of is obviously how the courts might deal with their situation and their sort of vulnerable status. So I think it's probably worth touching on the kind of protective measures that could be put in place for someone who is attending court. That could include things like asking the judge to list an online hearing, so you could be, within the comfort of your own home. You could have screens up within the courtroom. You could have separate waiting rooms, entrances and exits, and things like that. And I think that's definitely a positive, inclusion, and something which can help to make someone already going through a difficult process feel a little bit more safe doing so. But I agree. I think it's one step in a potentially long journey.
Do you at Oasis have support? Do you support people at court? At court?
At court?
Yeah.
Where capacity allows. Not as much as we would like. It's something that we absolutely want to do more of, and that's something that we're working on. But the sheer number of people engaged in proceedings means that it would be near impossible to support everyone. So I suppose you have to focus on the highest need, but we'd absolutely love to. There are some really, really useful guidance and guidelines online. There are some good resources. There are a couple of charities that have created really good videos and written guides on what it's like to attend court on your own, how to be a litigant in person, particularly through the domestic abuse lens. So there's an organisation called IDAS. So they've got some fantastic guides, and as have Rights of Women. So anyone can access those online, and I think if you were going to court and you knew that you weren't going to have specialist support with you, hopefully you'd take a friend or family member with you, but maybe considering those guides as well would be helpful.
Yeah, I think going back to, obviously we spoke about Practice Direction 12J and how that applies to proceedings where there are children, but I think also it could be helpful to touch on children proceedings themselves, and by that I mean any kind of proceedings where you're asking the court to make an order in respect of children, whether it's to do with child arrangements, whether it's to do with sort of determining a specific issue or anything else really. Essentially, where issues of domestic abuse arise, the court have the power, and this is another thing that's contained within Practice Direction 12J, they have the power to consider and to order a fact-finding hearing, and this is something that we see quite often. Obviously, when you make an application, you can bring these kind of allegations within your application, and you can tell the court what's happened, and how it's affected you and what kind of services you've sought out. But the court can obviously take that further, and they can try and get away from that he said, she said issue that we spoke about, and they can look at the evidence in more detail within its own hearing, and kind of try and get to the bottom of that. And I think sometimes that can be troublesome and sometimes it can be beneficial. Obviously, it relates to the evidence problem that we spoke about before, where if the court are having a hearing to look at evidence, it's not always going to be the case that evidence is available. So it can be difficult to kind of emphasise, I suppose, the seriousness of what has occurred, and I suppose to show that to a judge who to a degree has to rely on your word, and in circumstances where the other party is saying otherwise, it can be really difficult. But obviously, if you have strong evidence, and again, particularly, the most serious of cases of sort of violence and things like that, there can be really compelling evidence. And so a fact-finding hearing kind of puts it to bed, where the other party's saying, no, that didn't happen.
Yeah, I mean, the purpose of the fact-finding hearing being to determine essentially if there is truth within the allegations that you're bringing, and it's all about the purpose of then the court being able to determine what should happen in relation to the child arrangements, so arrangements for that child or children, who they should be spending time with, and in what circumstances, in what situation, whether it should be sort of direct contact or overnight staying contact and all that sort of thing. So it's brought in when and used when necessary as a tool to allow them to look at ultimately the arrangements and who should be spending time with children. So in that kind of arena.
Yeah, and it can obviously be a very difficult time for a victim to go through that fact-finding hearing, but it can also be really important because actually I used to find that's when the noise of the legal proceedings would fall away, and when you're hearing the words, the actual words of the client, it was always powerful. Hearing and seeing someone and their body language and their responses, that's really important. And judges are very good. They've heard a lot of these cases, they've seen a lot of people, and that is their time to really assess what's going on. So I generally found that although they were very difficult for victims to go through, generally they considered that to have been a good process.
And I think that's, I suppose, the other thing, isn't it, is everyone sometimes wants their day in court and they want to be heard and to feel seen. So sometimes that just sort of psychologically can have benefit. But obviously the flip side of that is that it is another court hearing. The preparation of that, the evidence and, costs and things like that are another consideration. So, again, not to deter anyone from going through that process because it's all things that need to be heard. But it's another thing, obviously, to consider.
Yeah. Fantastic. Holly, thank you so much for coming in and speaking to us. And thank you very much for listening.